Sorry for the delay. We are calling to order public meeting 119 of the Massachusetts Gaming Commission. We are at the Convention Center as usual. It is about 10:35 in the morning. There were a couple of loose ends maybe from yesterday. I think the way we set these agendas, that it's okay if we close a loop left over from yesterday?
Yes, any matters that we didn't finish up on yesterday, we can take up today.
Right, okay. So before we get into these items, were there any leftover loose ends from yesterday?
Well, perhaps just a minor one. So are we scheduling a hearing like yesterday's for next Thursday? Was that an understood or implicit date to schedule?
We took the commission's direction to schedule it on the 8th. We could schedule it on the 8th or the 9th if it was more convenient either way.
Yeah, originally I had said let's let a couple of days go by before we decide, because on the theory that maybe there was a lot of action and maybe things would get resolved quickly, maybe it wouldn't even be necessary. Now I'm not sure how much action there is. I just don't have any idea. So we don't really have to cross this bridge at the moment, but it's certainly going to be the 8th or the 9th. The 8th is Thursday.
Yes,
Yeah.
out of state on the 9th.
Okay. So Commissioner Cameron's out of state on the 9th, so it looks like it's going to be on the 8th. But that's not absolutely cast in stone.
We have 48 hours before that time.
Yeah, about
to do
48
it.
hours, right. So that means certainly no later than Monday morning, we got to make a final decision. But there are some conflicts on in the morning, or that whole day, but we'll fix them if we have to. And we do have, a non-trivial task. We know about the documents that we're working on. But it looks like we may be stuck with the 8th if the 9th isn't a possibility. But is that okay?
That's fine.
We're all right with everything else? Anything else left over from?
Well, we don't necessarily have to start at 10:30 on the 8th, right?
No, we could start
No.
whenever we want it, yeah.
Okay.
Right. Okay, so we are to item number 2, the Ombudsman Report, Ombudsman Ziemba.
Thank you, Mr. Chairman, Commissioners. So we have a couple items up for consideration today. As you know, Longmeadow and West Springfield and MGM have concluded their arbitrations, and the arbitrators have issued their reports. All of those parties submitted fundamentally consistent petitions to the Commission. We are hearing those today. Council Blue will take us through that process.
Thank you. For the benefit of the folks in the audience and for the folks who are watching us at home, I thought I'd put a little bit of the background on the record so we can kind of understand where we are at this point. Section 15 of Chapter 23K requires that applicants provide to the Commission signed agreements with surrounding communities. The statute further provides that surrounding community agreements shall include a community impact fee and all stipulations of responsibilities between the applicant and the community, including stipulations of known impacts from the development and operation of the gaming establishment. The Commission, in its regulations, in particular 205 CMR 125, established the process for determining surrounding communities and the execution of surrounding community agreements. 205 CMR 125.016 describes the 2 phases of the process: the negotiation phase, where the applicant and the community have 30 days from the time the Commission makes a surrounding community designation to negotiate an agreement, and the arbitration phase, where the applicant and the community failing to negotiate an agreement have a roughly 30-day period to engage in arbitration to arrive at an agreement. The Commission's regulations regarding arbitration required that each party submit a best and final offer in the form of a surrounding community agreement. The arbitrator is required to pick one of the offers, incorporate that offer into a report. That becomes a surrounding community agreement. The parties have 5 days after the arbitrator's award to sign the surrounding community agreement that contains the terms of the best and final offer selected by the arbitrator. At the Commission's March 4th meeting, a concern was raised about a situation where both parties to an arbitration may make potentially unrealistic offers, and how the arbitrator could address that situation. The Commission reviewed the issue and recommended that the arbitration regulations be amended to provide a safety valve, an option for the Commission to review the arbitrator's award to determine if any of the provisions of the award are fundamentally inconsistent with the terms of Chapter 23K. If the Commission finds that a provision of the arbitrator's award is fundamentally inconsistent with Chapter 23K, the Commission can modify or amend that provision. The amended regulations required that if a party believed that the provisions of the other party's best and final offer contain provisions that are fundamentally inconsistent, the party had 5 days after the filing of the best and final offers to file a petition outlining its objections and the provisions objected to with the Commission. The regulations requires that the Commission hold a hearing after the arbitrator's award to consider objections raised in the petition filed by the party whose best and final offer was not selected. In Region B, there were 2 arbitrations, one between MGM and West Springfield and one between MGM and Longmeadow. The parties selected an arbitration panel for each arbitration. A hearing was held where testimony was taken and documents submitted. Both parties to each arbitration filed petitions with the Commission citing provisions in each agreement that they believed were fundamentally inconsistent with Chapter 23K. The arbitration panel in West Springfield selected the West Springfield's best and final offer as the surrounding community agreement. The arbitration panel in Longmeadow, in a split decision, selected the Longmeadow best and final offer as the surrounding community agreement.
Excuse me, did you say the West Springfield was unanimous?
Yes, it was.
Okay.
In the Commission packet today, you have the best and final offer from each municipality, the petition from MGM outlining their objections to certain provisions in the municipality's best and final offer, the arbitrator's award for each arbitration, and a chart put together by staff listing MGM's objections to each municipality's best and final offer, including a recommendation by staff as to whether the provision objected to is fundamentally inconsistent with Chapter 23K. The Commission can review the objections made and determine if the provision objected to is fundamentally inconsistent. If the Commission finds a provision is fundamentally inconsistent with 23K, it can amend or modify the provision, and that includes making a change to that provision or deleting it in its entirety. Once the Commission completes its review, the agreement, either as is or if modified, becomes a surrounding community agreement and must be executed by the parties and filed with the Commission. Are there any questions I can answer?
No, I think that's very helpful and succinct analysis.
So you can, I would use, the easiest way may be to start with your charts and go through the objections one by one, discuss them and determine whether you agree with staff's recommendation or have other questions or concerns.
Council, we should probably mention that there were submissions by the parties. One as recently as last evening, there was a submission by MGM. I believe it's approximately 270 pages with exhibits. And then after that filing, there was an objection to that filing from the town of Longmeadow. We have not had the opportunity to review in depth those filings, but I think perhaps there are a couple of ways that we can deal with those filings today. Council, would you like me to give a recommendation?
Yeah, go ahead.
So one potential recommendation, Commissioners, is that the Commission could make their determination today based on the filings that were made, the initial fundamental inconsistency petition filing, make their determination based on that filing in the context of the staff recommendation. To the degree that upon any further review by the Commissioners over the next few days, if they deem anything in the subsequent filings that were put forward by the parties, if they deem that those would otherwise change any determination on a fundamental inconsistency petition matter, then at its next meeting, the Commission could reorder or take another look at that filing. The reason why I am recommending the split on that of an initial determination today and reviewing the matter subsequently at the next meeting is because we are hoping to conclude our, we're hoping to issue an award shortly in Region B. If we wait until our next meeting, which would probably be Thursday, under our regulations, after we make our determinations on fundamental inconsistency petitions, there are 5 working days. 5 working days after our decision before the agreement becomes final. If you add those 5 working days, we would not be able to have our closing of our hearing in Western Mass to enable us to issue our award.
We would not be able to have the closing of our hearing.
Because if we are anticipating that the close of our hearing would be on May 14th,
Yeah.
which would enable us to issue the determination on the award on June 13th. So if you add the 5 working days to next Thursday, we would not be able to do the closing of the hearing the following week.
Wouldn't that just mean instead of June 13th, we'd be at June 18th?
We would be at June 18th. We would have to refigure all of our calendars, obviously, to see if we can make our award decisions at a later date. But what this would allow is if the commission makes its determination today, the parties could utilize that 5 days that we have included in our regulations to determine whether or not they want to have some sort of an alternative surrounding community agreement instead of the commissioner's, instead of the arbitrator's decision. During that 5-day period that we've added to our decisions, we would then make any determination if we need to reverse any decisions that are made today. So if we reverse those decisions, we would reopen it, and then we would have to delay the issue of the Region B award. But other than that, I don't think that we could recommend making a determination on that, at least on that 270-page filing, without being able to fully review it.
Well, I agree with that. I haven't seen it. So is there anything in the reg that pertains to submissions that come in last night? Wasn't there a time frame during which people could submit?
The regulations provide for really 2 forms of filings: the filing of the petitions with the best and final offer at the start of the process.
Which is what we have.
It's what you have, and then filings that have been filed with the arbitrator. The regulation does not provide for any post-arbitration award filings, which is what these are.
So we could ignore it or not?
That's
to
correct.
us. Presumably it's materially, I guess it must be, I don't know why they would submit it if it wasn't materially different somehow or other from the one that we've already got.
Well, Mr. Chairman, we are now getting to a stage in which we are getting from a number of fronts 11+ hour filings. We got one yesterday, the day before yesterday. We got
Yesterday.
We got 2 yesterday, one 270 pages in length last night. I haven't seen it either. And I think that throughout the process, we have tried to be accommodating and bend over backwards to be accommodating, to accept everybody's information and to be as informed as we possibly can before we make these important decisions. I think that we need to continue to do that. That is unclear. I think we need to continue, of course, to be as fully informed as is reasonably possible as we move this process forward. But I don't think we can continue to take action that encourages filings at 4 o'clock, 5 o'clock, 8 o'clock on the night before a meeting occurs. And so I'd be prepared to say our regulations do not apply, do not permit these filings, and we're going to ignore them and move forward. There is always the risk, I think, that in doing that, you ignore something that's material. But it seems to me that this has gotten to a stage where the sound progress of our processes is being jeopardized by what's happening. So that's what I'd recommend doing. If the commission is not in agreement with that, then I think the alternative is to proceed today under the suggestion that was just made and reconsider and take a look at the filings that were made. And if there's anything in there that causes us, or any one of us, to think that we need to reconsider a decision we made today, then to reopen the hearing and have that discussion in public. The other problem, of course, is that we can't discuss any of this in private. So that, and we can't have a meeting to discuss it unless we have a 2-day posting. As with a number of other things, if, for example, if we hadn't already scheduled a meeting, we couldn't have discussed the request for more time that we got at 4 o'clock yesterday or Wednesday. I'm rambling now. I've made my point. That's the process, I think.
One other fact I think we should mention is that, so the filing as of last evening was one of the filings. We did receive filings earlier in the week from, West Springfield concluded its arbitration last week. We received a comment letter from the town of West Springfield earlier in the week. We had advised all the parties that under our regulations, there are no formal submissions allowed. But as has always been our practice, if anyone submits a comment letter about anything, our practice has been that we read it. Unfortunately, when we mentioned that to them, the parties, that we read everything, I think it spurred further ability to submit filings, even though when that's not contemplated under our regulations.
I think that's a valid point, and I guess I was expressing a little frustration without thinking things through. I would favor, under those circumstances, the moving forward today and reading it, and if there's anything that causes us to reconsider what we've done, that we reopen the hearing. I think we need to move forward, and I think we need to consider the materials that have been filed. I think that's the fairest way to proceed.
I would agree. I think it's important to follow our regulations, to meet our deadlines when at all possible, and make a decision. And if there is something that really is material, we'll have an opportunity to address it.
Is the way the reg works is when the BAFO is submitted, there is an opportunity for comment on whether or not it is believed to be fundamentally inconsistent. Both parties do it because nobody knows which BAFO is going to get picked, but nothing can change because the BAFO can't be moderated. So is there anything that has happened, that happens in the process between the time the appropriate opportunity for filing comment on fundamentally inconsistent feature is filed, and now, or did they just not do enough work? Nothing's changed, right? Whatever is in that 275-page document could have been in the original filing. So it's not there's a structural inconsistency that we've opened up here.
I think that's true. The only change, the material change, is the arbitrators issued an award.
Right.
You know, I will say that we have, obviously, applicants and municipalities who are represented by very good counsel, and in general, counsel feel as though they want to zealously advocate for their clients, and they like to submit comments in situations where, you know, for example, the award has been issued. So there may be comments that may be more directly pointed towards the award and how that award was phrased by the arbitrators. But the fundamental provisions of the agreement did not change.
Right.
No.
I think I agree with General Counsel Blue, but I also think that the big change is the arbitration proceedings themselves. And I noticed in some of the filings we received references to the transcript, and it may well be that the filing last night talked about the evidence that was presented to the arbitrator and the resulting award being in some view wholly inconsistent, therefore fundamentally inconsistent with the statute. I mean, I think that's the big change that occurred.
Right.
I've got substantive views as to that, but I do think that may be part of what's at issue.
And one other thing to mention, our regulations, Mr. Chairman, they only contemplate that you have the filing where you're objecting to a certain provision. There's no provisions in our reg that allow for a response to the objection. So even though there was nothing changed between that period of time, the party whose best and final is being objected to never had the opportunity under our reg to file a defense of their agreement.
How much time are they given, either by regulation or by the schedule, between the time that they receive each other's BAFOs and the time that they file the fundamentally inconsistent petition?
They have 5 days, and as we count, it's a period of time less than 7, so we would count.
That's a
They
week.
probably could potentially have a little more than 5 days, but roughly 5 days after they share their best and finals to provide their objections and file with the commission.
And that period was done purposefully to send a message to all of the parties that this process was not meant as an appeal of an arbitrator's award. It was meant to cure fundamental inconsistencies with the statute. And so I think we have heard from other parties recently saying, oh, we'll have all of our objections ready on best and final offers, et cetera. We'll make a very large submission. I don't believe that was ever the intention of the commission, that we will open up an opportunity for folks to submit issues on everything that are more relative to whether or not the award is sound or not.
Yep. No, that's a good point. However, some of these submissions were quite lengthy, the BAFOs themselves. They included big binders with many studies, and in a worst-case scenario, the other party may have or may have not seen some of those materials.
Well, those materials were submitted to the arbitrator, and in the arbitration proceeding, they would have had the opportunity to respond to that or to submit other evidence. I
Right.
mean,
Oh, good.
yes, no, they should have been exchanged and responded
They
to.
had a hearing, an all-day hearing, right, where testimony was taken
They
by the
did.
arbitrators. All of that information was, there was a chance to explain, a chance to make your argument.
That's correct.
Before the BAFO was presented.
No, as part of the
Part of
arbitration
the arbitration
proceeding.
process.
The crux of the,
Yeah.
the BAFOs were relatively succinct.
Are we anticipating that the parties are going to speak? I know Attorney Silverstein is here, the MGM is here.
The commission can, according to our regulations, the commission can take oral testimony in its sole discretion. We had advised the parties earlier that the commission would not be taking oral testimony, but this was before we got some of these additional filings.
Okay, so the question on the table is, do we take your recommendation? And I'm still not quite sure why we couldn't just add 5 days on to the end, but I guess it doesn't really matter. If we take your recommendation, and we may have to add the 5 days if we decide we have to open it, but maybe we don't, so there's no point in debating that. So what do you folks think about the recommendation that's on the table? John, of the
Yeah.
process recommendation, that we go ahead and make a decision, and that is the decision unless we find something that
And
makes
Mr. Chairman,
causes to reopen.
separately, if you wanted to consider, now that it appears that all of the parties are here, if you wanted to consider that they be able to speak for 5 minutes, that is also a potential that could aid in your decision-making.
Yeah.
We had advised them all, in fairness to them, that would not be the process.
Yeah, well, I think your point, we know we've opened a can of worms here, and we've got to keep our, we will stay focused on exactly what this was when it came up, which is a very narrow and specific function that we meant to be protecting. And of course, you know, everybody's going to jump into that wedge and make it as wide as they possibly can, and it's up to us to make sure that we don't let it get opened up. Having said that, I'm inclined to let people speak their piece. I mean, that's sort of consistent with what we've been doing here. And so, you know, my inclination would be to go on the process that you have suggested, and to offer the two parties, or three parties, I guess, an opportunity to speak for a relatively few minutes to make their critical highlight points.
I'm not sure I understand what you mean by opened a can of worms, Mr. Chairman.
Well,
What worms are in what can?
the worms are that the fundamentally inconsistent clause has given, as the council were saying, the loser an opportunity to appeal on a whole host of grounds.
That's not my view of it at all, Mr. Chairman, and that is partly what we're attempting to demonstrate today. My view is that we have a very narrow standard. We have said that from the beginning, that we have a very narrow standard, that this is not an appeal, that this is an opportunity to prevent something that is fundamentally inconsistent with the statute from going forward. And to characterize it as an appeal, I think, does both today's proceedings and the record that we're trying to create in a clear manner as we can a disservice.
No,
and so
that's what
I retreat entirely from that characterization of what we're doing.
I'm on your side on this. This is not an appeal, but that they are trying to construe it as such and claiming points that you might, for example, going back into the transcript and deciding whether the hearing was conducted properly. That's not within the realm of what we have here.
Yes, sir.
And I agree with you. I think as a practical matter, I'm pretty sure when we see that 275 pages, it's going to have a lot more than what we were anticipating as a fundamentally inconsistent claim. But our job is to make sure that we stick with what we're talking about, which is this very, very narrow standard. This is not an appeal of the decision. I'm totally with you on that. That was their characterization, not mine.
Yeah, I apologize for bringing up the word appeal. When I mentioned that, I was mentioning that so to forestall any future submissions where people might think that it is an appeal, exactly what Commissioner McHugh had just stated as well.
I agree too. Okay, are we agreed to go forward with this process as proposed and to let the applicants speak for?
Well, I guess I have an issue with the process. They were told they would not have an opportunity to speak here today. They were told that by our staff, and now we are changing what the staff has told people would be the process. And I frankly don't see the need to hear. We've heard from these folks on this matter a number of times. And I was, personally thought the arbitration process, when I read through it, was very thorough. Lots of opportunity to speak and present witnesses, testimony, documents. I'm frankly not convinced that we need to do that at this phase.
Maybe I'm putting a very fine point into that, but they were told they would not have an opportunity to speak before they submitted 273 pages. Is that correct?
That's correct.
Right. So if we wanted, I'm curious as to what does that contain? I'd be curious to hear if they're willing to tell us, a 5-minute summary of what's been submitted. But I agree with making a decision today, reading any materials that they send us, when our time and schedule permits it, and then making a decision whether to open or not at a later time, whether to reopen or not.
So you're inclined to let people speak? Is that what you're
Yes.
saying? Commissioner Stebbins, do you have a say?
I agree with the general notion of making a decision today and giving staff the chance to review anything that's come in. We might find ourselves, if we offer the parties a chance to speak, that maybe we won't need to entertain that time to go through a 270-page brief or any of the other filings from the other parties. And that next step, we might not have to undertake it, depending on what's told to us today.
Sound like maybe a soft majority for speaking, so.
But I would just add that I have no objection to brief speaking, but if they were told that they were not going to speak and are not prepared to speak, I think it's unfair. So it's at their option, and if they exercise the option not to speak, that's not something that will be held against them.
There's no
I think
prejudice
that
involved,
is-
right.
I think that is essential. Careful lawyers are wary of speaking in this kind of an environment extemporaneously and without careful preparation. So that's my view. It's their option, and nothing will be held against them if they elect not to do it. And
Okay. Agreed.
Agreed.
Agreed. Okay, so I guess, what's the protocol for who goes first?
So I think what we should do is we should go in alphabetical order by community. And first, we would have the community speak, and then the brief response, very contained, whatever period you think is fair, Mr. Chairman. Then we would go to West Springfield, and then a final response from
Right.
MGM.
I'm just going to say arbitrarily, 10 minutes is max. And we hope that you will take seriously what we're saying about there's a narrow window here. If you've got stuff that, honest to God, no kidding, you really fundamentally believe is inconsistent with Chapter 23K and not other chaff, lay it out there. But please don't take our time for stuff that's, is a waste of our time. So with that, I guess it would be counsel for Long Meadow, if he or she chooses to speak. That's a bad sign.
Good morning, members of the commission. My name is Brandon Moss. I'm here on behalf of the town of Long Meadow. I have the town manager. I have Stephen Crane. I have Marie Angelides, the chair of the select board. I don't intend to have them speak. I just want to point out that they're in the room. This is a bad sign, but it was a bad sign for the arbitrator. It's not a bad sign for this commission. We had a very thorough process, and as the staff recommendations on the chart that I've seen that's in the commissioner's packet reflect, these are not issues of fundamental inconsistency in terms of the Long Meadow best and final offer. The 270-page filing that I received yesterday at 4:30 attempts to basically get a third bite at the apple by, in track changes mode, making changes to a number of provisions that could have been made back on April 3rd or before April 3rd when the MGM's objection was filed. The requested changes from yesterday, they do not relate to, although there's a transcript and that accounts for the bulk of what was submitted yesterday afternoon. The changes are not anything that relates to, frankly, it doesn't make changes based on this binder, based on the transcript, which I took the liberty of putting that into a second binder. We get our exercise with this case, with the number of binders we have. But frankly, these issues could have been raised back with the objection, and they weren't. In terms of the changes that MGM's now proposed, there are a number of completely different arguments. The objection that was filed by MGM back on April 3rd dealt with alleging that it was a taking, alleging that the amounts were taxes for the mitigation, alleging that positive impacts should offset negative impacts to essentially reduce the mitigation payments, and also trying to draw an arbitrary cap on consulting and legal fees. Those were the arguments made. The arguments, that came in last night, or yesterday afternoon, I'm sorry, try to create substantive changes to the Long Meadow Best and Final Offer Agreement that the majority of the arbitration panel accepted. It tries to create a new adjustment procedure for payments. It tries to create a new procedure for determining adverse impact amounts. One of the components of the Long Meadow Agreement, and when we were here back in January, we were here back in February, we had the report, the 170-page report by the Commission's consultants. We listened, Long Meadow listened. Housing, schools, a number of issues, code enforcement, water, sewer. The Commission's own consultants said there were non-impacts, so we didn't put those in the Long Meadow Agreement. We only focused on two issues of traffic and public safety that our experts in this binder, in part, demonstrated that there are going to be traffic and public safety issues and considerations. MGM is now is substantively, with some of the reply from yesterday in Exhibit A, study scope, MGM is attempting to take that and put that now into a study scope area to basically offset impacts. That's substantive. That is not fundamentally inconsistent. The standard is very narrow, and it is a very specific standard. These issues are not issues of fundamental inconsistency. These are really an attempt to take a third bite at the apple. And certainly, where there's a dispute on some of the provisions, frankly, the Expanded Gaming Act requires an applicant to provide mitigation. And that's what the Long Meadow Agreement does. But it's not an issue of fundamental inconsistency, the issues that MGM's raising. And that's a very high standard. It can be, to uphold an agreement, it must be consistent with the act. But to adjust terms, it has to be fundamentally inconsistent. And certainly that's not the case. So that's what I am here to say this morning. I'm certainly welcome any questions from the commission.
Anybody?
Okay.
Questions? Thank you.
Thank you.
MGM. Good morning.
Good morning. Good morning, Commissioners. Seth Stratton, I'm local counsel for MGM, and with me, you of course recognize Mr. Mathis. Let me start out by just addressing the question of the volume of the submission. It was approximately 270-page submission. It's a four-page brief. The 270 pages is the transcript from the arbitration proceedings, because there are certain references in both party submissions to that proceeding, and we thought the commission would benefit from having that available should it choose to reference it. But the issue raised by MGM is a four-page brief raising one issue, which is the very same issue raised in the underlying objection that was filed to the BAFO 5 days after the exchange of those BAFOs. And that's the issue that we've had all along and that we raised with the arbitrators, which is that there's a fundamental inconsistency with fixed payment amounts that are not tied to known impacts. That's exactly
what?
That are not tied to known impacts, Your Honor. And that's exactly what we objected to early on. And the issue we had, and the reason for the subsequent filing, is that you'll see from our papers that we believe the arbitrators felt constrained by the change in the regulations, the early regulation that allowed them some ability to alter, to address fundamental inconsistencies. And then the removal of that, it's clear, if you see the transcripts and what we've highlighted, that the arbitrators felt that their hands were tied. And while they might have liked to make some changes to make it more, to address those inconsistencies, they weren't able to do so. And we believe that when the commission made that change, it reserved it to itself its ability to address exactly that issue. And that's the only issue we're raising. We're not appealing.
Exactly that issue, meaning fundamental inconsistencies?
Fundamental inconsistency of having fixed payments which we
Okay,
believe
that
are
issue,
not
okay.
tied to actual known impacts. And that's the only issue we raise again. We're disappointed with the results. We're not seeking to change the numbers. We're willing to live with those, but what we've submitted to the commission is a proposal which we think the commission could act upon to cure that one inconsistency, which is the lack of tying known impacts to the amounts. And the way we do that, keep in mind, is that we have this look-back program. And our concern is that to have these much larger fixed payments, which we believe aren't tied to known and specific impacts, paired with a broad and open-ended look-back, guarantees a floor, but also has the look-back, so there's a potential for windfall. All we're asking to do is to adjust the look-back so that it can go both ways. If these look-back studies show no impact, or less than the payments, then they can be adjusted either way. And we believe that would address the inconsistency. And so what we've attached is, rather than just asking the commission to address that, we've attached a proposal that the commission could act on, which we believe would keep the same agreements, 90% of the agreements the same, the money the same, but changes the program, the look back, so that it goes both ways. And that's the proposal that we've attached for the consideration of the commission, which we believe addresses exactly our underlying objection.
Where do you come up with the Chapter 23 fundamental commitment of surrounding community mitigation fees must be tied to known demonstrable impacts? Where is that?
We believe that that's referenced specifically in there are a number of references. I think Chapter 23K, Section 15, subsection 9, refers to known impacts from the development.
But I have that section here, and it says, surrounding community agreements must, quote, include a community impact fee for each surrounding community and all stipulations of responsibilities between each surrounding community and the applicant, including stipulations of known impacts from the development and operation of a gaming establishment. That sounds to me like it says that the surrounding community agreement must stipulate known impacts, but I don't see any tie between the community impact fee and the known impacts.
So we believe if you read the statute as a whole, and as we've listened, as we've read the regulations and listened to the commission throughout this process, believe there have been numerous references to knowable and actual impacts, and that the process is directed at figuring out what the actual impacts are going to be so that these communities don't get a windfall. And that's the nature of our objection, frankly, that the legal objections which we filed is that if MGM is forced to pay payments that don't have a nexus to actual impacts, that's an unlawful tax and a governmental taking. And those are the legal objections underlying our position. And so we believe that Chapter 23K is consistent with having these impact payments tied to actual impacts. And the reason we took the approach of a look-back study is that that's inherently hard to do. It was hard for us to do. We think it was very hard for the communities to do. It was hard for the arbitrators to do, and frankly, hard for this commission to do, and that's why we've proposed this look-back study, and we understand that the communities think it's imperfect, and the arbitrators had concerns with it. So the increased dollars that the arbitrators have said are appropriate address the concern of not having enough money to address impacts up front. We've resigned ourselves to that, but we're saying if you're increasing these numbers, and it turns out that by using this money, you mitigate the impacts, and 5-10 years down the road, they're not there, or the fears and concerns didn't materialize, why have these higher floors? Why can't the look back adjust downward as well as upward? We're giving the benefit to the communities of having the ability to mitigate the risk of the number being wrong, too low. Well, mitigating the risk of it being too high as well, and allowing it to be downwardly adjusted is more consistent, we believe, with the Gaming Act.
Commissioners, if I can, I just want to say briefly, it's hard for me to say this, it's hard for our company to say this, because we really believe in our position, but we accept that we lost each of those arbitrations. We're not here to appeal those. We want the process to move forward, and if you were to accept the BAFOs of each of those communities in whole, we would accept that and move on. What we've offered today is what we believe is a way to accept those BAFOs and cure what we think is a fundamentally inconsistent provision of those BAFOs, which establishes minimum payments regardless of impact. That just strikes us as inconsistent with the Act and inconsistent with the way we've treated our other 6 surrounding communities. So we're not only here on our behalf, but we're here, frankly, on behalf of those communities that agreed to our look-back approach and an attempt to make these agreements consistent with with those discussions and those representations. So with that, I don't know if you have any questions for us, but again, appreciate the process, want to move it forward, and we'll accept the decision of this commission either way.
And Commissioners, it's the exact same response, I believe, to what will be raised by West Springfield. So unless there's something new or a question that comes up, that's our position, and I don't think we need to respond.
What is the fixed ongoing, is that 275,000
For Long Meadow,
or 370?
For Long Meadow, the BAF award was 275 fixed. For West Springfield, 425. And in comparison, the communities, the larger cities under our surrounding community agreements are getting 150,000, and the smaller communities 100. So these are, these two, the upfront payments are significantly higher than
Yeah.
the other communities, and the fixed
It's
payments
just,
are.
I just wanted to remember what the, so it's the annual payments are ongoing annual are 275 and 425.
That's right.
Yeah, okay. Any other questions, thoughts?
Thank you.
Thank you.
All right, thank you. I have just this piece of section 15(9). Is there any other guidance in the statute? I mean, I don't know that my memory and reading of it is that that it is fundamentally inconsistent with Chapter 23K that there be a payment in a surrounding community agreement that happens to be in excess of a direct impact. But is there any more guidance in the statute than the section that you have in your analysis? Are you looking at it too, Joe?
I'm not looking at the statute.
Okay.
No, I have an idea. I have thoughts about the question you just asked, but
I have always looked at Section 9 or Section 15. I don't believe, but I have not gone through the statute recently in that detail, but I don't believe there's anything that ties it specifically to impacts.
Just, in terms of what the spirit was. Okay.
I don't think there's any provision that specifically talks about that, but I think that the clear import of the statute is that there be a nexus between impacts of the facility and the remediation cost of those impacts. So that is, it seems to me, a principle, and I do intend to comment on that as we get into this further in one instance. But how you determine what those impacts are is an entirely different story, and the statute's silent as to that. The look-back provision is one way of doing it. It's not the only one. Arbitrators, judges, courts frequently are engaged in projection of future losses, future impacts, future consequences of a present act. And so the fact that an arbitrator chooses or is bound to choose between two competing ways of looking at how to measure the impact, it seems to me, does not make either method fundamentally inconsistent with the statute. So I would tie it to impacts as opposed to tribute or something else, and but say that there are at least two ways of measuring or attempting to measure that impact.
And so how does that cut bottom line?
Well, insofar as this is concerned, this award is concerned, I think there are areas in here that are within the arbitrator's discretion, and most of them, in my view, are. I mean, I'd be happy to go through, if we go through them one by one, we can talk about that, because I don't know how you were planning to do that.
But so as you apply the analysis that you just got through discussing, your bottom line is that you don't see any fundamentally inconsistent. Is that what your bottom line conclusion is?
Well, I do see, I do not see any fundamental inconsistency between the upfront payment of $850,000 for the purposes stated and the statute. I don't see any fundamental inconsistency. One may disagree with the number. There may be evidence in the record that supports a different number, but I think that is something that's within the arbitrator's call. I don't see any fundamental inconsistency between the $275,000 annual payments or the cost escalator and the purposes for which those monies are to be devoted. I will note, however, that it seems to me that the public safety component of that expenditure, and I'm quoting now, to mitigate significant and adverse impacts within the community consisting of projected traffic and roadway and infrastructure impacts and public safety personnel and response cost impacts. The public safety and response cost impacts is troublesome to me, not potentially troublesome to me, not because it's fundamentally inconsistent with the statute, but because of the Emerson College case, which talks about the difference between a fee and a tax. And I make no judgment about that. It's not part of our purview, but it is there and it is an issue. I think there are differences between what one can do voluntarily in a community agreement surrounding a host and what one can be compelled by the state to do in a community agreement surrounding a host. So the bottom line for that is that I don't see any fundamental inconsistency with the statute and the $275,000 payment. I do see one other, I do see one fundamental inconsistency, and that I'll put on the table, and that is the legal fees. The provision in the agreement as it presently reads says, and I quote, "Notwithstanding anything otherwise provided in this agreement, at the time of the execution hereof, the community may provide MGM with invoices evidencing legal and consulting fees and expenses the community has incurred for the time period through the date of this agreement in connection with evaluating potential impacts from the project, seeking designation from the Commission as a surrounding community and negotiating a potential surrounding community agreement, including through arbitration." I think that a provision that does not qualify those invoices with the word reasonable is fundamentally inconsistent with the statute. And that again goes back to the idea that the thrust of the statute is to mitigate the adverse impacts of the project, and not to allow somebody, town, subcontractor to the town, to reap a windfall. So I think that anything that simply requires the applicant to pay whatever fees for whatever costs are provided to it in connection with the process is fundamentally inconsistent, and there needs to be a reasonable clause, reasonable word in there. So I would alter the agreement with that one word.
Does the absence of that word, I can see why you were a judge, by the way, does the absence of that word permit unreasonable fees, or will the law impute the word?
I don't think as it goes, this is a contract in which that word isn't there. This is going to be viewed as a contract in which that word isn't there.
So even if it were treated as a windfall for the, and if it were handled in bad faith, in effect, the MGM wouldn't really have any recourse without that word.
Right.
Interesting.
I mean, that's certainly a risk.
Right.
We are the enforcing body, I would think, in the first instance. It's an administrative proceeding, but that's a risk. But without that, we wouldn't be able to enforce them.
Other thoughts or comments?
I would agree with that. I think legal fees in the context of of a long-term, open-ended nature can amount to substantial amounts, and that does sound like not the intention of impacts versus mitigation monies.
These legal fees are a one-time payment.
Just to pass it
It's
Just a one-time payment?
up to and through
up
this.
to and through the agreement. But it still doesn't contain any reasonableness limitation. I mean, presumably, it is going to be reasonable, that's not a problem. But there are situations and times in which things aren't reasonable.
Well,
Anything else? There's, to me, the key, I take your point on the reasonable, I would have missed that, but that sounds appropriate to me. An important finding, apropos of the reasonableness or relevance of the size of the impact payments, and if they're tied to actual impacts or not, I think is anticipated by the arbitrator, who said that the proposed payments appear to be lower than the actual cost the town will incur in responding to the likely impacts relating to traffic and public safety. So within the context of their capacity, you know, they did make the decision. They did believe, as a matter of fact, that from what they knew, those were going to be tied de facto to. So I think it's a really interesting point, and whether it would be inconsistent or not is fundamentally inconsistent or not is worth talking about, but in another context, but I think this finding makes it clear that the arbitrator did not see this as tribute or as a fee or as a tax, whatever it was, but saw it as within the reasonable range of the costs of impacts.
But those amounts were submitted to the arbitrator?
Yes.
Right.
Yes, they were.
And they're not part of the 850?
Well, the amounts on the legal fees, I don't know, but the number.
No, this is talking about the two payments, the upfront, the one-time and the ongoing 275.
Oh,
The arbitrator is saying that, among other things, not the legal fees, right?
sorry, I was a little asleep.
I don't know why, this is really interesting. I don't know why you went to sleep. Okay, so any further discussion, thoughts? So we will need a motion, I guess, and we will probably turn to our motion maven.
I move that we, that the commission deny the objections on grounds of fundamental inconsistency filed by MGM to the award of the arbitrators in the case of the town of Longmeadow, with the exception of the objection insofar as invoices for legal and consulting fees are concerned, and that insofar as that provision of the agreement is concerned, that the commission modify the language currently existing in the best and final offer with the word reasonable, so that, or reasonably, so that the provision reads that the community may provide MGM with invoices reasonably evidencing, reasonable legal and consulting fees and expenses the community has incurred.
Second?
Second.
Any further discussion?
What section of the BAFO are you incorporating that into?
Section 2, which is on the final page of the staff recommendation.
Got it, Commissioner? Any further discussion? All in favor of the motion as proposed, signify by saying aye.
Aye.
All opposed, signify by saying nay. The ayes have it unanimously. Okay, West Springfield.
Good morning, Commissioners. Jonathan Silverstein for the town of West Springfield. I'll be brief in light of the Commission's action on the FIP to Long Meadow's best and final offer. Maybe I'll just make a couple of points in response to discussion among the commissioners. Anticipating Commissioner McHugh's motion, and I said this, by the way, in my, you may not have had a chance to read every page that was filed with the arbitration proceedings, but I specifically stated in my brief to the arbitral panel that, of course, the town acknowledges and accepts that any fees for which it seeks reimbursement must be reasonable. And on behalf of the town, I would suggest and agree that the term reasonable be included at the end of the 5th line in section 1, so that it would read, MGM shall reimburse the town for the actual and reasonable expenses incurred by the town. Certainly was never the intention of the town, to the contrary. And I'll note that MGM offered in its BAFO $125,000 specifically for consultant and legal expenses. That presumably was not intended to address the increased costs to the town of having to go through the arbitration process, because at no point did MGM actually negotiate. They simply said, well, this is the agreement that we gave Agawam and Chicopee, and take it or leave it. And that's why we ended up having to go through a very lengthy and expensive arbitration proceeding. And there were certainly additional costs to the town as a result that I don't think the town should have to incur. The town's probably going to be looking for around $25,000 or $30,000 above what MGM had already offered for consulting and legal fees. So we're not talking orders of magnitude difference. In any case, certainly we'll agree to the insertion of the term reasonable. I do want to note also that the mayor had been planning to attend today, but when we were informed there'd be no statements from the parties, he decided it wasn't worth the rather lengthy trip out. So I would just note that his absence certainly is not an indication of the degree of importance that he views this proceeding. This is a matter of utmost concern to him. And I think if you look at the arbitration transcript, if you're having trouble sleeping at night, perhaps you'll want to do that, and you'll see that he was extremely earnest and eloquent in his statement of the concerns of the town regarding this project. I guess I won't address some of the other comments made by MGM because I think they were adequately addressed. I do note that we had an extremely distinguished arbitral panel of 3 very respected jurists who unanimously determined not only that the town's BAFO was more fair and reasonable, but that it dramatically understated, and we talk about the issue of the nexus between impact payments and impacts. The arbitral panel unanimously stated that the payments called for in the town's BAFO are much lower than the impact it's actually going to experience. And so I don't think there's any question about a nexus. I think the commission's acknowledged its role is not to second-guess factual findings like that by the panel, and clearly I think it's not fundamentally inconsistent. As to the issue of MGM wanting to have the look-back process look back both ways, we made our best and final offer incorporating the exact look-back process that MGM had been pushing, and we submitted a much lower impact payment than the impacts we actually believe we will experience, specifically based on that framework. We would have come up with a different BAFO if it had been a framework such as what MGM is suggesting, and they didn't include it in their initial fundamental inconsistency petition, so we never had the ability to address that issue before.
Are you saying that the MGM BAFO had a look-back provision which did not permit the payment to go down?
Exactly. Okay. The only difference, I hewed as closely as possible to MGM's form, which they repeatedly throughout the process said was very important to them. Really, the primary differences are just the payment amounts, and that's a factual determination that the arbitral panel unanimously made. MGM makes one argument in their filing last night that they didn't make in their FIP, and it's this. The upfront payment that they are to pay West Springfield, $665,000 for a study of the Memorial Avenue reconstruction project. They claim that that would be a windfall for the town because there's a provision in the transportation bond bill for $3 million of funding for that project. Let me make a couple very quick points on that. They were made at the arbitration proceeding, and the arbitral panel clearly considered those in making its decision. Number one, the $3 million has not been approved. It's a provision in a bill. Pure and simple. Number two, the $3 million represents 50% of the actual construction costs of that project. Number three, that $3 million does not include, it's $6 million of construction costs, $665,000 entirely separate for design, permitting, and engineering. That's what the upfront payment is for. Two separate issues. The $3 million under the bond bill could not be used for that purpose. And so there's no suggestion of a windfall here. The town is committed to using that money for the stated purpose. With that, I'll rest. I will note that to the extent that MGM thinks that there's some risk of an enormous windfall to the town, there's a reopener provision in the commission's regulations. And if there's an unexpected adverse circumstance that could trigger that reopener provision, MGM can take advantage of it. I'll note that they wanted to force the town to waive that provision in their best and final offer. We did not include such a waiver for either party in ours. So they'll have the full ability if there's some major adverse unforeseen circumstance to take advantage of that if they so choose.
Would
Other than that,
would a major adverse circumstance be if the annual payments was demonstrably higher than the actual impacts?
I can't speak to what that might include. Ultimately, that would be for the commission to determine, I think. But I think that, for instance, if the town were to receive 100% funding for the Memorial Avenue project, including engineering, design, and permitting, perhaps that MGM might be able to make the argument, hey, this really is just a windfall to the town.
Because you're suggesting that the reopener is a protection for the interests that they are trying to protect, which suggests that if there were a discrepancy between the payments and the actual demonstrable actual costs, that you would consider that a legitimate reason for reopening.
I think that that's an argument MGM could make
Well,
depending on the
you're
factual circumstances.
I'm just pointing out that you're setting that out as a protection for MGM. You're persuading us that it was a good clause because it gives them a way to sort of backdoor this issue.
I don't think, I think every case would have to be dealt with on the merits, Mr. Chairman. I don't mean to evade, but if MGM comes in and says, look, we think we're paying $50,000 a year too much, here's our evidence that the impacts are really only $325,000, our impact payment is only $375,000, then I don't think that is the type of magnitude that the regulation contemplates. So I think there are different circumstances under which MGM could try to make that argument. I'm not going to sit here and make it for them in any particular circumstance. I do think there is some protection built into the regulations. But nothing MGM has argued demonstrates a fundamental inconsistency with the statute.
Questions?
Section 2, in Section 2, when talking
Section
about
2 of what? Of the
West Springfield BAFA, Section 2 of the West Springfield BAFA.
okay.
Okay. Following the description of the amounts that are to be paid, there is this sentence: the parties acknowledge that the community shall be free to direct the annual mitigation payment and the annual study cost reimbursement, together the annual payments, to any uses it deems appropriate, and shall not be restricted to use the funds for any purpose set forth herein. How is that, why is that not fundamentally inconsistent with the statute?
Commissioner, as I indicated, I tried my best to hew to the exact language of MGM's BAFO as possible. that exact language is in Section 2 of MGM's BAFO. I cut and pasted it. So, number one, I think it's not appropriate for MGM to contest that language where it comes from their language. But the other thing I would suggest, Commissioner, is that nothing in the town is going to incur these costs. The arbitral panel found that. Nothing in the statute states that particular payments have to have a linear relationship to how the town addresses impacts. It requires an impact fee. It requires an assessment of impacts. All of that has been done by the arbitral panel. I would also note that this language, I suspect, was added by MGM after a number of communities raised concerns about the fact that in Massachusetts, municipal finance laws restrict the ways in which funds that are paid to a municipality can be earmarked for particular purposes. Under Chapter 40 of the general laws, there are very strict limits on the ways in which funds paid to a municipality can be earmarked, only under certain circumstances. In fact, I think the commission adopted its letter of authorization process in response to exactly that concern, because this can't be considered a gift under Section 53A of Chapter 40. It can't be considered a revolving account or an enterprise fund or any of the other very narrow class of special funds that can be set up by a municipality. And many cases stand for the proposition that you cannot bind the hands of the appropriation authority through a contract or any other instrument without statutory authorization to do so. So I think this is simply consistent with municipal finance laws. It doesn't change the fact that there is a stated nexus, as found by the panel, the arbitral panel, between the impacts that the town will experience and the payments that are being made. How the town chooses to deal with those impacts and utilize the funds, that's a matter that cannot be limited by a contract.
I hear you.
Any other questions for Attorney Silverstein? Thank you.
Thank you for the opportunity.
Thank you.
MGM?
Sorry, of course, you always end up eating those words when you say you won't say anything. Very briefly. Commissioners, Attorney Silverstein just mentioned something which I think is important for the commissioners to think about. He said that the arbitration panel found that the town's going to incur these costs. All we're saying is, if they were wrong, if they don't, let us get a credit towards future payments. We're doing the studies anyway. It's in the agreement. We're doing it with all the communities. We're looking at impacts. The panel had to choose between two numbers. And that, I think, if you look at the papers we submitted, was the concern and why we think we disagree that they found this to be the impact number, because they were just choosing between two. If they thought it was 200, they wouldn't want to give them only 100, but
They didn't find it to be the impact numbers. They said that they appear to be lower than the actual cost the town will incur.
Fair enough, Chairman. And I guess the point is, if they're wrong, all we're saying is, if the money for Memorial Drive fixes the issue, and there are no impacts, and the impact studies show that, maybe those impacts won't be there, and why not give us a credit? That said, so that's just to highlight the potential that if they were wrong, and we're being forced to pay money in addition to the impacts, then there is potential for a tribute. And if the commission is comfortable with that, subject to our ability to reopen, then MGM is willing to live with it. But we just want to highlight that by pairing the guess on what the impact will be, which I agree with you, Judge McHugh, they have the ability to do that, but then to pair it with the look-back study as well, and not allow a downward adjustment, Certainly, there is the potential for a tribute, but subject to the reopener, so long as the commission's comfortable with that potential.
Did I hear Attorney Silverstein correctly that in your BAFOs with the, in your agreements with other towns, the look back does not have the reduction clause in it?
That's right, because we voluntarily offered those, and we were comfortable with at the threshold, the number threshold, that there
Right,
wouldn't be.
I got that, but the finder of fact here, in this case, found the threshold to be a legitimate threshold too. You know, the finder of fact here, the arbitrator disagreed with your judgment that this was not a reasonable number. In other words, the finder of fact believed this was a reasonable estimate of the costs, and therefore went with your principle of not having a reduction in place.
I agree with you, Chairman, and I guess our only point is that because this is, we disagree with that threshold, but it's essentially government-compelled threshold that's different when we're offering it. And if it's wrong, and the look-back studies show that it's way above what the actual impact is, then it is indeed a tribute. And so long as there's, the commission's comfortable
I think
with that potential.
also, Attorney Silverstein, you said if it's, I forget what the word was, you'd modify, if it's substantially different, there's a real significant difference between the real costs and the payment. Even Attorney Silverstein suggested that the reopener clause might be applicable. So, I mean, it sounds like it's a pretty good argument that if there's a big problem here, that you already have a protection against.
Thank you.
Discussion.
I had two concerns, one of which Mr. Silverstein has conceded on. I think we ought to formalize it, and that is both in Section 1 and Section 2. In the fee and expense reimbursement provisions, there is no reasonable qualification, but Mr. Silverstein said that was intended. It seems to me we ought to make that formal. The other thing I question Mr. Silverstein on is that provision that says that the parties acknowledge the communities shall be free to direct the annual and mitigation and study cost reimbursements to any uses it deems appropriate, and shall not be restricted to use the funds for any purpose set forth herein. That strikes me as tribute, not accounting. You can account for it any way they want, but that strikes me as allowing use of these monies to feed the swans in the town pond, and that's not part of mitigation. So I would strike that clause from the best and final offer. Again, I make the distinction between what parties can do voluntarily and what they can do under the compulsion of the state. And it is a provision that one could not object to, would not object to perhaps if it were in a voluntary agreement, but this is not in the end a voluntary agreement, so I would strike that.
That doesn't seem right to me. It seems to me that tribute is the purpose for which the monies are provided, not the purposes for which the monies are spent. And whether or not this is in fact money generated because of impacts is dealt with in this decision. The arbitrators felt that these numbers were in fact representational of likely actual costs as best they were able to figure out. So in their view, this money will be paid as a consequence of impacts. If a city or town says, you know, well, we have a higher priority than filling all those potholes, and that's to hire another teacher, yeah, we're going to take the money that we got for the potholes and put it to the teacher. I don't see that as changing the nature of the relationship, the nature of the payment. It makes the changer of the use of the payment, which seems to me it ought to be completely within the discretion of the town.
We just disagree.
Yeah, that's fair.
I'm only somewhat familiar with the point Mr. Silverstein was making relative to municipal finance law. But would it be relevant to insert a provision in within that language that would read something like subject to the requirements or constraints of municipal finance?
But it already is.
It already is de facto?
You know, and that doesn't go to Commissioner McHugh's point anyway. Otherwise, other than that issue, this is treading trod ground, right? We've just.
Yes, I think-
The issues are exactly analogous to the
Yes.
Long Meadow issues,
In my view, they
other
are,
than on
for
this
the
one.
same
So
reason.
we need to,
Right.
so we agree on adding the reasonable word, we agree that the others are not fundamentally inconsistent, the other objections are not fundamentally inconsistent. The only question is whether we agree or not with Commissioner McHugh's line on that, of that sentence.
I note that our legal staff did not pick that piece up as something that you felt was fundamentally inconsistent. Is that?
None of us has the nerve to disagree with
Well,
Judge McHugh.
but we need to get this right.
I actually
So-
disagree with him often.
On
It-
issues like this?
It
Not
was
on this
not
one,
objected to. We looked at what was objected to by MGM, and that provision was not objected to by MGM. I am not familiar with municipal finance law, so I really can't speak one way or the other as to, what issue that could raise.
I don't think this has anything to do with municipal finance law.
I don't know.
Okay, yeah. Anybody else want to weigh in on that
Well,
or explore it more?
it would be an opinion that is not based on necessarily what the law says, so that's why I asked our legal staff to help there if they had any knowledge of this matter.
Well, if the question is, does this in a significant way suggest tribute as opposed to impact? Does this clause really make this tribute, enforcing an illegitimate tax on a community?
That's the essence of it, and I understand your thoughtful suggestion that the measurement of the payment is the impact, the dollar value of the impact, and then once the payment is received, the town can choose to use it for things other than mitigating the impact. So I understand that. My thought is that, particularly under the force of a state mandate, the monies to be consistent, not fundamentally inconsistent with the statute, have to be used to mitigate impacts. And this allows use of those monies for something else and is therefore fundamentally inconsistent with the statute. Those are the two different positions.
I'll say this one more time. I actually don't think the law says anything about, if they weren't thinking about this for sure, but it was to compensate for impacts. I would have said, not to fix the impacts.
Well, surely there's no express language, but I
Whatever.
disagree with that.
Yeah, okay.
I mean, we just are bound to disagree.
I
Which happens.
agree with Commissioner McHugh's suggestion of striking that provision.
Yeah, I'm going to weigh in on that side as well, frankly. The argument makes sense, and having been in a position over the years of trying to enforce using certain monies for the right things, that would make sense to me, too, that was the intention, to use it for impacts.
Because your experience in trying to enforce the uses for the right things,
Yes.
that is a constructive strategy, you're saying that is supportive of this. All right, well, that's three, so does it?
Yeah, no big surprise. I mean, I'm going to be for. The parties acknowledge the community shall be free. It's talking about money going into an annual mitigation payment, annual cost steady cost reimbursement. I simply have a problem with it being used for something beyond that.
I'm sorry?
I simply have a problem with it being used for something beyond that, or,
Okay. Well, interestingly, in that case, if there were a big difference between the actual impacts and the money being paid, there'd be a kitty being built up.
That's right. This
I
is
have a
likely,
feeling that'll probably never happen, but.
no, but this may likely be a multi-year evaluation of things, and
Yeah, okay.
a reserve may be very helpful in actual future impact mitigation.
Right, and but it also potentially feeds into the discussion you had with Mr. Silverstein about what happens if there's a big delta.
Right. Okay, do you want to put that into motion?
All right, I move that the commission deny the objection of MGM to the arbitrator's award of the best and final offer to West Springfield, with the exception of adding the word reasonable in the two sections, sections 1 and 2, that discuss payment of legal fees and other expenses, and with the exception of striking from section 2, the phrase, quote, "The parties acknowledge that the community shall be free to direct the annual mitigation payment and annual study cost reimbursement, together the annual payments, to any uses it deems appropriate, and shall not be restricted to use the funds for any purpose set forth herein," close quote. Period.
second.
Any further discussion? All in favor, say aye.
Aye.
All opposed, nay, for the reason I,
Right.
everything else I'm agreeing with, but not that one clause.
All right.
Okay, I think that's it for item A.
Mr. Chairman, it might be helpful at this point to, just for the record, to state that we will take no further filings or comments on this matter, that we have completed it and no further submissions will be necessary.
Yeah, I was
Right.
about to say that the preliminary motion and subsequent review, now it doesn't have to take place.
If the commission is comfortable with that, I think that would be fine.
Yeah, I think we got the synopsis courteously from MGM's counsel, and I think we've now dealt with the substance of that. All right.
All right, thank you.
Out of respect for our Western Mass media and other reasons, let's take a quick break, and we will come back for item 2B. Thank you, folks.
Thank you.